Namaste and welcome to Lahari's classes. Welcome back to Indian Polity article by article series. This is lecture 4.2 of Directive Principles of State Policy. We will be discussing about articles 45 till 51, and by this lecture we will be finishing with Directive Principles of State Policy. So let's begin. Article 45 talks about early childhood care and education. Article 45, after the 86th Amendment Act 2002, it states that the state must provide early childhood care and education for all children below 6 years of age. So this talk about less than 6 years of age. In fundamental rights, we will come across a right which talks about education to children between 6 to 14 years. Here in this article 45, it discusses about children getting educated below 6 years of age. So accordingly, the government must make provisions to implement this directive principle. Next is article 45. The continuation. We have certain real life implementation of this article 45, that is the government came up with Anganwadi centers under ICDS scheme, which provides nutrition, offer preschool education, health checkups and vaccinations for children below 6 years. And another scheme, Poshan Abhiyan, which is a national mission to improve nutrition in children under 6 years, which helps in their monitoring of their growth, to provide healthy diet and reduce malnutrition amongst those children. Article 46 talks about promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. Accordingly, the state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particularly of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation. According to this principle, the government came up with the reservation in education for like providing SC/ST quotas, providing them scholarships and fee waiver. Also, the government time to time provides special budget for every year for SCs and STs for their developmental programs. Next is article 47, which talks about the duty of the state to raise nutrition, standard of living and public health, and also to reduce consumption of intoxicating drinks and harmful drugs, except for medical purposes. Accordingly, the government came up with midday meal scheme, that is now PM Poshan Abhiyan, national health mission to through government hospitals providing free medicines, maternal care, vaccinations, etc. to improve the public health, like alcoholic restrictions. The states like Bihar and Gujarat implements liquor prohibition to curb harmful drinking, etc. Article 48 talks about organization of agriculture and animal husbandry on modern and scientific lines. They will take steps for preserving and improving the breeds and prohibiting the slaughter of cows and calves and other milch and draught cattle. Accordingly, the government came up with National Dairy Plan, Mission Milk, in order to improve the improving the quality of milk, improving the breeds, etc. to protect cows, other cattle. Many states like UP, Gujarat, Madhya Pradesh have strict anti-cow slaughter laws to implement this policy. Next is article 48A, which talks about protection and improvement of environment and to safeguard the forests and wildlife of the country. Accordingly, the government establishes national parks, wildlife sanctuaries, they comes up with pollution control laws and tree planting programs like through Green India Mission in order to enforce this principle. Next is article 49, which talks about protection of monuments and heritage of our country. That is, it shall be the obligation of the state to protect every monument or place or object of artistic or historic interest to be of national importance from spoliation, disfigurement, destruction, removal, disposal or export as the case may be. Like we have World Heritage sites like Taj Mahal, Red Fort, Hampi, etc. The government takes such steps so that the constructions around these heritage sites will be restricted to prevent damage to these monuments. Next is Article 50, which talks about separation of judiciary and executive, because to maintain checks and balances, also to make the judiciary do its work without any compulsions from the executive. So that's why the state shall take steps to separate the judiciary from the executive in the public services of the state to ensure independent justice, fair and independent justice. So the executive magistrates and judicial magistrates have separate roles to perform, which directly helps in enforcing this principle. And district judiciary functioning independently of district administration also comes under this principle. Next is last one, Article 51, which talks about promotion of international peace and cooperation. So with other countries, we have to promote peace and cooperation. So Article 51 Clause A talks about promoting international peace and security. For that purpose, India sends troops for UN peacekeeping missions in countries like Congo, Lebanon, South Sudan, etc. This shows that India's commitment to world peace. Article 51 Clause B talks about maintaining just and honorable relations between nations. For this reason, we have international organizations like SAARC, BIMSTEC. We have bilateral ties with foreign countries in order to have friendly relations, and humanitarian aid to countries in crisis. We are giving aid to we have already given aid to economic crisis in Sri Lanka, like many countries. Next is Article 51 Clause C, which is respecting international law and treaty obligations. Like we follow Paris Climate Agreement guidelines. We respect WTO trade rules also, UN treaties. Article 51 Clause D talks about encouraging settlement of international disputes by arbitration, that is peaceful methods but not by war. India and Bangladesh on the same lines resolved their maritime boundary dispute peacefully through international arbitration in 2014. India often takes border disputes to negotiation tables rather than war. Next is for understanding purpose, we have divided the principles into socialistic, Gandhian and liberal principles. But in constitution there is no such differentiation as socialistic or Gandhian, etc. But for our convenience, we have divided these principles into three types, that is first we will discuss about these socialistic principles. These aim to provide social and economic justice. Article 38, 39, 39A, 41, 42, 43, 43A, 47 come under socialistic principles. Next is Gandhian principles. It reflects the Gandhi's ideology of self-sufficient villages. So Article 40, 43, 46, 47 and 48 come under Gandhian principles. Next is liberal or intellectual principles, which aim to build liberal and humane society. Article 44, 45, 48, 49, 50 and 51 come under this liberal principles. Next is simply summarizing those three principles, like socialistic principles for economic justice and welfare state, Gandhian principles for village economy, self-reliance and prohibition of liquor consumption, toxic drugs, etc. Next is liberal intellectual principles, promote global peace, uniform civil code and modern governance. So we will just revise the key amendments. Through 42nd Amendment Act, 39A, 43A and 48A were introduced, and through 44th Amendment Act 1978, they gave primacy to some fundamental rights over DPSPs, and from 86th Amendment Act 2002, Right to Education, Article 21A was added, which is linked to Article 45 in Directive Principles of State Policy. So the significance of DPSPs, as we have discussed, they reflect the ideals of the preamble. They guide the state in policy making. They are guidelines, instructions, etc. They supplement the fundamental rights. Nothing is superior over the other, but they both are complementary to each other, and they promote welfare, equality, and justice. Next, through multiple judgments by the Supreme Court, the conflict between fundamental rights and DPSPs has been resolved. Initially, it was declared by the Supreme Court that fundamental rights prevail and have more significance than DPSPs in Champakam Dorai Rajan case in 1951. That is, they gave priority to priority to fundamental rights, but the government came up with the 25th Amendment Act in 1971, which gave priority to DPSPs in order to promote welfare amongst the needy, that is 39B and 39C over certain fundamental rights. So it introduced Article 31C. But in the Keshwananda Bharati case in 1973, followed by this Amendment Act, the Supreme Court declared that Parliament cannot destroy the basic structure while amending the fundamental rights. DPSPs are important, but there has to be a balance between these two. So a partial balance was restored after this case. But in the Minerva Mills case in 1980, the Supreme Court clearly said that fundamental rights and DPSPs are complementary to each other but not conflicting. Neither is superior. A balance must be maintained. So we follow this as of now. That is, fundamental rights are not superior than DPSPs, or DPSPs are not superior than fundamental rights. They both are complementary to each other. So we have concluded with the DPSPs. In the next lecture, we will be discussing about fundamental duties, which come under Part 4A, which are included in Article 51A. So thank you so much for watching till the end. Please subscribe for more Indian polity lessons. God bless you all. Jai Hind.